Today I'm going to talk a little bit about copyright and fair use. Copyright broadly comes under the Copyright, Designs and Patents Act of 1988. The Act identifies three categories of works in which copyright subsists. These are original literary, musical, dramatical or artistic works. Secondly, sound recordings, films and broadcasts. Finally, typographical arrangements of published editions. There are lots of key factors when it comes to copyright. For example, it must be more than what we call de minimis. For example, a single word will not usually attract copyright. Of course, it must also be original and fixed, meaning ideas themselves don't attract copyright. It must be fixed in some kind of permanent format. Although compilations themselves can attract copyright in their own right if there's sufficient skill used in bringing various different forms together into a new form. It's also important to understand that a single piece may involve more than one copyright. For example, if I create a piece of music and record it, there will be copyright not only in the music itself, which will be committed to a permanent form, but there'll be copyright in the sound recording and there'll be copyright in the film of the recording. The Act also defines the author of a work as the person who has expended the effort, skill and labour in producing it. Although it's important to understand there can be more than one author in the case of joint authors, so long as the contributions of each cannot be distinguished from each other. For example, if one person has exclusively produced the sound effects, whereas a second person has produced the spoken word, they can be distinguished and not necessarily joint authors of the overall piece. Important also that ownership and authorship do not necessarily coincide, although the author is generally the first owner of copyright. An obvious example of where this is decided on a case-by-case basis is where works are produced under employment. It will largely depend on whether it was produced under a contract of service or a contract for service. In other words, if it is produced during the course of employment, it will usually belong to the employer. Whereas in the latter case, if the works are produced under a contract for service, then the ownership will stay with the author, unless of course there is any clear agreement to the contrary. In other words, the copyright in a commissioned work will still belong to the author unless there is a clear agreement otherwise. The current duration of copyright is the life of the author plus 70 years, which replaced the old regime of the life of the author plus 50 years. Although the duration of copyright in secondary works is slightly different. So what is copyright and why do we actually need it? Well, the owner of a copyright has the exclusive right as follows. Firstly, the exclusive right to copy the work, to issue copies of the work to the public, to perform, show or play the work in public, to otherwise communicate the work to the public, or to make any adaptation to the work, or do any of the previous elements with regard to that adaptation. So I have a little bit of a story and a warning to share, in that I've been a musician most of my life, and when I was around 17 years old, I was called to a studio because somebody heard and liked my work, as in the work and the music that I created myself. I arrived at the studio, there was lots of equipment, and I was told that I could play around and play all my pieces and play with the equipment, as it was much better than the equipment I had. Unbeknownst to me, all of what I was playing was being recorded. In other words, even if I hadn't already recorded my own music, my own creations, they were now being recorded and fixed in a permanent form on this studio's software. Now clearly, taking what I've explained about copyright, I, as the author, was the first owner of this copyright, regardless of whether I had previously recorded it, because it was new, it was my creation, and I played it, and it was recorded in a permanent form, albeit it wasn't my equipment. I owned the copyright. But some 6 or 7 years later, I heard a piece of music that sounded awfully familiar. There was a certain pattern and a certain phrase, and it was clearly the main attraction of that song. A little bit curious, I went home and got some of my old recordings where I'd recorded all of my own previous songs, and I listened back to them one after another, and sure enough, eventually I found exactly that same phrase, which couldn't possibly have been a coincidence. It was a deliberate melodic phrase, albeit based on a chord sequence, but it was a very distinct musical phrase, and I firmly believe that that copyright of mine was stolen and used to produce music. Now, of course, many songs will use the same chord sequence to each other. For example, Pachelbel's Canon has a very famous chord sequence that everybody will recognize, and in fact, lots and lots of pop songs and different kinds of songs use exactly that chord sequence, as I'll show you some examples of right now. So while this is what we might call cribbing, it depends on how much of a copyrighted work is being used as to whether or not it is infringing that copyright, all of which is a matter of degrees and decided on the facts of any given case. So how is it then, you ask, that lots of published material make use of other people's copyright without getting into any trouble? Now, aside from the fact that copyright is often used without the consent of the owner, but without any follow-up action from the owner, the most typical use of copyright is that with permission, of course. Permission is sought from the copyright owner or owners and can be given on a very specific basis, or it can be a more general basis. In addition to this, Section 28 of the Act sets out various permitted acts which will not infringe copyright. For example, making temporary copies of something will not infringe copyright. Think when you're browsing the website, your computer must download images, literary content, music, sounds, and so on, and make temporary copies of them on your computer so that you can view them locally. Now, strictly speaking, this is making copies of copyrighted work, which in any other scenario would not normally be permitted. But in this case, because it is deemed to be a temporary copy, this is a permitted act. But one aspect that I do want to talk about is that of fair dealing or fair use of copyright. Now, fair dealing has been said to be impossible to define, but nonetheless, there are some guidelines. One of those elements concerns how much of the copyrighted work you have used. For example, if you get a copyright complaint on YouTube, one of the questions is going to be based around how much of the copyrighted work you've used in creating your video. Now, the Act does not define how much of a work that you need to use before it constitutes infringement. So again, it's a matter of degrees and how much was necessary to create your new work. News reporting is another obvious example for any sort of work other than a photograph, research and private study, material used in the public interest defence, and of course criticism and review, which is one of those that I am interested in when creating new videos. In particular, in one of my videos, I did a little bit of a breakdown of one of BBC's episodes of Silk. I took little snippets of the video to comment on what was accurate, what might not be so accurate, to produce another video that has some entertainment value for you to watch, but is not a replacement for watching the original episode. So in this case, the primary work that was created by me was obviously my video doing a, let's call it, criticism and review of that first episode. It was necessary to take small chunks of the original copyrighted work of the BBC to slot into my video to show you that portion and then comment and review. And I did this all the way through. Ultimately, there was only a few minutes of a whole episode of Silk that I used in my video, and obviously the primary video that you were watching would be mine. This is a great example of what constitutes fair dealing and fair use of copyright. Obvious channel examples spring to mind are CinemaSins and Screen Junkies. Clearly they use lots of copyrighted material to produce every one of their videos, so if you want to see more videos like that on BBC Silk from me, let me know in the comments. So that was just a brief overview for part 1 of what will be my copyright series. Let me know in the comments what other aspects of copyright you are interested in. They will constitute part of part 2. And of course, don't forget to like, comment and subscribe, and I'll see you next time. Don't know if I've recorded enough.